Hey, welcome back. Today we're here talking about premises liability, and we're going to do it in a structured way.
First, we're going to discuss a really strong hypothetical case, a personal injury case. And then we're going to discuss a similar but weaker version of the same fact pattern. And then lastly, we'll dive into two real Washington cases that mirror those outcomes.
Yeah, so let's start with a scenario that, from a plaintiff's perspective, checks a lot of the boxes. So a woman goes to the grocery store in the evening. The parking lot is dim, functional, but not great. As she walks towards the entrance, she trips over a low concrete wheel stop. The problem is that the wheel stop is the same gray color as the pavement, with no paint or reflective markings. So she falls and fractures her wrist. After the incident, it comes out that the store employees had previously reported people tripping over the same wheel stop, and there were no changes made. No paint, no warnings, no lighting improvements. So, Mallory, what do you think about this case?
Yeah, from a legal standpoint, this is a pretty strong premises liability case. First, she's clearly a business invitee, so the store has a duty to her to maintain a reasonably safe conditions so that she's not injured unnecessarily. Second, there's a strong argument that the store breached that duty that they owed her. This tripping hazard that blends into the ground, that's a wheel stop that's the same color as the pavement, especially given that there's poor lighting in the parking lot. That's not just a minor defect. That's something that a jury could reasonably see as an unreasonably dangerous condition. And third, this is often the most important piece of these kinds of cases. There's notice here, right? The store had prior complaints. That means they knew or should have known about the hazard and they had an opportunity to fix it. Finally, something that makes this case really great is that causation and damages are straightforward. She tripped on this dangerous condition and she suffered a real injury. Her wrist was fractured. The defense will almost certainly in case like this argue that the condition was open and obvious, something that sometimes shields businesses from liability in these situations. But that argument weakens significantly when the hazard is hard to see, especially at night with poor lighting and when there's evidence that others have had the same problem. So this is the kind of case that typically gets past summary judgment and often has real settlement and trial value.
Yeah, and what we know from practice is if you can get past summary judgment, then they're really going to put some real value on the case. And like you said, this has all the elements of a good premise of the liability case. Notice the employee had noticed that it was a tripping hazard and that there was injuries in the past. The injuries, the wrist fracture, it's objectively verifiable injury. The dark lighting, the gray color makes it not as open and obvious as somebody might argue. So, all the good elements for a good premise of liability case. Now, let's look at the same basic facts, but set up and changed a few ways with a couple different details. So, we got the same grocery store, same parking lot, same wheel stop. But this time, it's in the middle of the day. The lighting's great. The wheel stop is painted bright yellow, clearly contrasting with the pavement. And importantly, the woman admits in her deposition that she noticed the wheel stop when she walked into the store. But on the way out, she was looking at her phone, and that's why she tripped over it. This case looks very different than the prior one. And the key issue here is the open and obvious doctrine that Mallory you mentioned earlier. In Washington, property owners generally do have a duty to protect against hazards that are readily apparent and avoidable. Here, the condition is clearly visible, it's clearly marked, and previously observed by the plaintiff herself. So that combination makes it very difficult to argue that the property owner breached any duty.
Yeah, on top of that, the plaintiff's own conduct here becomes really central. If she saw the hazard earlier, understood its presence, and then failed to avoid it because she was distracted on her phone, that makes a jury much more likely to assign significant comparative fault or even conclude that the property owner isn't liable at all. So even though the physical object, the wheel stop where she tripped, is identical in both of these hypotheticals, the context changes everything about the strength of the case. The lighting, the visibility, the prior awareness of both the business and the individual, all of those factors can shift this case from a strong case to a weak case.
Yeah, so let's connect that first hypothetical, to a real Washington case. In Gould v. North Kitsap Business Park, the plaintiff tripped over a wheel stop in a parking lot, very similar to our first scenario. And the key facts were the wheel stop was not painted or otherwise highlighted. It blended into the surrounding pavement. And then there was evidence that the defendant had notice of the hazard, including prior incidents. So the case went to trial, and the plaintiff obtained a favorable verdict, which was upheld on appeal. The reasoning aligns closely with what we've discussed earlier, that the court focused on whether the condition posed an unreasonable risk of harm and whether it was readily observable. Because the hazard was difficult to see and the defendant had prior notice, the court allowed the plaintiff's claim to proceed and ultimately succeed. This case reinforces a key point. When a condition is camouflaged and known to the property owner, it becomes much harder for the defense to rely on the open and obvious doctrine.
Absolutely. Now compare that case to a real case in Washington where the defense won. In this case, Corwin v. City of Kent, the plaintiff was injured in an outdoor public area and claimed that the city failed to maintain safe premises. So this actually happened in a lake. Someone was wading through the lake and tripped over something that he believed should not have been there, and the city should have known it was there and removed it. The problem that the plaintiff ran into here was lack of notice. So we talked about how important that notice piece is. And in this case, there was no evidence that the city knew about that hazardous condition or that it existed for long enough for the city to reasonably discover it. So they didn't know about it and they didn't have constructive knowledge of it, right? It's not like they should have known about it if they had done their reasonable due diligence, right? So under Washington law, that is essential. The plaintiff must show that the defendant had actual or constructive notice of the dangerous condition. And without that, the claim fails, even if the condition itself was hazardous. So here in this case, the court granted summary judgment for the defense, and that decision was upheld on appeal. And this case highlights that premises liability, it's not just about whether something was dangerous. It's also about whether the defendant had a fair opportunity to fix that condition, whether they knew about it and whether they had a duty to fix that and make it safe for the person who was injured.
Yeah, so stepping back, these cases, both the hypothetical ones and the real ones, show how small factual differences can completely change the outcome of the case. So there's four major factors that tend to drive these cases. Number one, probably the most important one, is notice. Did the property owner know or should they have known about the hazard? And then number two, was the condition hidden or obvious? And then number three, the plaintiff's conduct. Was the plaintiff acting reasonably, or were they distracted or just ignoring a known risk? And then the last one, context. Lighting, markings, prior incidents, all of these matter. When those factors line up in the plaintiff's favor, you get a case like our first hypothetical or Gould. And when they don't, you get outcomes like our second hypothetical or Corwin.
That's what makes premises liability cases so interesting and so tough and unpredictable. Two situations can look almost identical at first glance, but when you dig into the details of each situation, the legal outcome can be completely different. If you enjoyed this breakdown, we'll be doing more episodes comparing winning and losing claims across different areas of law. Thank you so much for listening, and we'll see you next time. And don't forget to watch your step.